Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamlin Harrigan, and today I'm going to be talking about when you're protected as an agent or representative of a corporation, limited liability company, or a person, and when you're not. So when you're acting as an agent or representative, when you have protections. And this could be a situation where you are a member or manager of a limited liability company, or a president or manager or other representative of a corporation. In some circumstances, you're protected. Sometimes you're not, as from personal liability. And we're going to be talking about that in today's vlog. You might also be in a situation where you're acting as an agent. If you're a real estate agent, there's a whole statute there. If you're an employee dealing with wages, there's another statute that specifically says that you're generally, if you're making the decisions as the person working and they don't get paid, you're liable for that. So there's statutes out there. But in the general sense, without the statutes, the question is, are you entering into an agreement with somebody or you're not? If I'm entering into an agreement with you and I'm signing as the manager, member, or president of a limited liability company corporation, you know what you're getting into. You know that I'm signing this on that the contractual obligation. I'm signing it on behalf of that entity, that principal. And in that circumstance, generally the law is, with some exceptions, and I've done some vlogs on what's called piercing the LLC or corporate veil. You can go to those to see. But with those types of exceptions, generally, you know what you're getting into. You can't go into my house if the company breaches the contract. Same thing if I'm an agent for a business sale, and you know that I'm doing this in a representative capacity and I'm not agreeing to anything else. Generally, in those situations, a breach of contract is something that you can't come after me as the agent for. What you can do is, if that person in that contractual situation is lying, they're committing fraud, that's what we call a tort. Torts are something that's outside a contract. That's, you're hurting somebody, you're taking actions, a wrongful act. There's both intentional, fraud is an intentional tort, or there's negligence. So by way of example, I'm not committing fraud in a situation, but I'm an agent for you, and I'm driving along and I hit Sally in a crosswalk because I'm answering a text from you. I'm driving and I shouldn't be doing that, and I hit that person. And I say, well, wait a minute, I was performing business for my employer or my agent, and therefore I should not be personally liable for it. You are personally liable for that. So negligence, intentional torts, you're personally liable for those situations, even though you're doing it inside the scope of your employment or your agency capacity. So in that circumstance, when you're thinking about perhaps starting your own company and you're thinking you're going to create an LLC or a corporation, perfect ideas. I've done other vlogs in regards to the benefit of a limited liability company for a small business. It makes a lot of sense. It also adds some substance to your business too when we're dealing with that. And then in contracts, when you enter into an agreement, absent what I've talked about in other vlogs as to piercing corporate veils, you have some protections there. So it makes perfect sense to do that if you don't sign a personal guarantee for certain obligations. Your lease, your loan with a bank, you're going to be signing a personal guarantee probably for. So if you're not signing as the direct tenant and the direct borrower, the bank's going to require that. So don't expect to get away from those. But the other trade creditors, you might be able to have a situation where you're just signing a limited liability capacity. But what is critical for this when you're entering into a business is get your insurance, get your liability insurance for whatever you're doing. So make sure that you have liability insurance for if somebody slips and falls at your business, or they say you did something negligent, or they say, in those situations you have insurance. If somebody's making an allegation that you committed some intentional or you lied or something like that, insurance won't cover that. Don't do it. And that's the way to avoid liability. Be clean and be fair. And then unfortunately, sometimes you might have some claims against you for claims of intentional torts you didn't commit, and it costs you money to deal with. Generally, you won't have insurance for that, but you're seriously limiting your liability by not doing harm to people, not intentionally trying to hurt somebody in regards to those situations. So for agency, you are liable for non-contractual liability, meaning somebody saying you're negligent did something wrong. They're saying you lied. That's an intentional tort. Those things are not covered by you. As the principal itself, if you're a principal and you're telling somebody to do something and they are doing it within the scope of their employment and they do something wrong, you're liable for that. It's called respondeat superior. The master stands in the shoes of basically the servant. So you ask somebody you have a salesperson and they're driving on a route to do a sale and they're actually going to a sale and they, again, maybe they're answering a text. If it's from you, then you're personally negligent for that anyway, if you know who they were driving. But if somebody else, they're answering their girlfriend, but they're still driving, or boyfriend, and they're still driving to a site, in that situation, they're doing this within the scope of their employment. More likely, you're going to be liable for that. But you have insurance for that. You should have insurance for your workers that are working out there. Make sure your commercial liability auto policy has coverage. Talk to your insurance companies to make sure you have proper coverage for those people because you are responsible for their actions. There's something called detour and frolic. That's a different area. By way of example, if you had a bouncer at a bar and he or she found a patron attractive and they went out into the parking lot, followed them, and they assaulted them, sexually assaulted them, in that situation, you can probably successfully argue that that was beyond the scope. That was not, they weren't doing something to benefit you. If the bouncer bounces somebody too hard because they're throwing them out, more likely you're responsible for that. So those are some of the laws in regards to principal and agency. I'm happy to answer any questions you have. I'm at 603-883-5501, 603-883-5501. I've been practicing law in New Hampshire for 39 years, Commonwealth of Massachusetts 30. I do weekly vlogs. Nationallaw.com is our website. You go to there, you go to my personal bio, and from there you can look at all my vlogs. Look forward to working with you. Opportunity arises. Dan Marr, 603-883-5501. Thank you.